Welcome to Philosophers.
The Business of Benefits is your no BS, no sales guide to real solutions.
No gimmicks, just the truth about how to take control, transform your benefits, and care for your most valuable asset, your people.
If you're tired of the same old sales pitch and you're ready to rethink your benefits, this podcast is for you. The truth is out there. Are you ready to hear it? Welcome to the Business of Benefits. This is Chelsea Rikus. Today I have on Jen Berman of MCQ Consulting. Jen is a mastermind when it comes to benefits compliance, employee benefits law, or ERISA law. We are specifically talking about, in a super quick episode, I will add. So this one's fiery, high energy, fast, get ready. We are talking about the JP Morgan ERISA breach of fiduciary duty healthcare lawsuit that just dropped a couple weeks ago. This is the third big one in the last year that has come about, and it's the one with the most teeth, and you're going to find out why. Something we didn't mention in the episode that I want to make sure people understand, in addition to what Jen will explain, which is this case proves more standing than the last two cases that have come out. It also names board of director members, whereas the Lewandowski case was mostly HR, benefits committee, CFO. The Wells Fargo, same thing. This case, however, is mentioning board of director members, which is something a little bit different. So she's going to go through what gives this case a little bit more teeth. She's going to share with us if she thinks this is going to be the one that makes it over the hill and actually comes to fruition. So she's also going to share some really practical tips for employers to avoid being in this position. And she's going to answer the question I think all of us are thinking, which is this going to come down market? These companies that are being sued, they're 150,000 plus employees, right? Massive companies. But the companies that I consult, they're usually under 10,000 employees, between 100 and 10,000 generally. So what about them? Is this coming? Is this really something they need to be worried about? And is that even the right question to be asking? All right, tune in, guys. Like, share, subscribe. Can't wait to hear what you think. Welcome to another episode of the Business of Benefits. This is the no BS, no sales guide, or no sales, no gimmicks guide for employers to quality healthcare. And I am super excited about our guest today. I consider her a friend. If you are in the industry and don't know who she is, I think you've been under a rock. We've got Jen Berman with MCQ. How are you, Jen?
I'm well. How are you, Chelsea?
I'm good. I haven't seen you in a while, so I'm really excited to catch up and have you on the show. Anytime something big happens in the industry, I'm like waiting to hear what you have to say on it. So we're happy to have you here today because there is a lot of big things happening. Before we get into the one main reason and the one main thing I want you to talk about today, why don't you just give our listeners, who are primarily employers, a little background on yourself and MCQ Consulting?
Absolutely. So I'm an employee benefits attorney by training. Spent about the first decade of my career representing large employers in the big law world, and then started MCQ Consulting about a decade ago, initially as an ACA reporting firm. And we have since expanded pretty dramatically to do all things employee benefits compliance. So we still do ACA reporting, but we now do mental health parity, plan documents, 5500s. Really, if it has to do with the benefits compliance world, we're in it and helping employers, advisors, vendors make sure that they are keeping those plans in compliance.
Love it. And Jen speaks all over the country to all sorts of audiences on how to stay compliant. And a super hot topic right now are these ERISA lawsuits. And that's what we're talking about today.
They certainly are. Yes.
Well, so we've talked about on the show before the Lewandowski and the Johnson & Johnson. We touched a little bit on Wells Fargo. I know there was a ruling yesterday. I'll let you give us the lowdown on that. But the main thing that I want to talk to you about today and get your opinion on is this newest case that dropped, I think, last week, if not the week before, JP Morgan Chase & Co. So let's start with that, and then we'll talk a bit how it compares to the other lawsuits. But can you give us the rundown on this most recent lawsuit, kind of the 360 degrees, and then we'll slowly get deeper and deeper into it?
Absolutely. So the JP Morgan case filed by the same plaintiff's attorney as J&J. So we're seeing an evolution in the world of these fiduciary cases. Similar theory, similar fact pattern. So we've got another one of these cases where we're saying we have a fiduciary breach because you've got a situation where a health plan is paying too much for prescription drugs, essentially. But we're seeing the plaintiff's attorneys or the plaintiff's case get a little bit smarter. So they're addressing the standing issue that we saw the J&J case get dismissed on. Although I'll note the J&J case is back. So even in the time since the JP Morgan case was introduced, the J&J case is now back. And then we saw Wells Fargo get dismissed on the same standing issue. So I think what's important, and we said this even as the J&J case, which is now a little over a year old, we warned people like this is, that one when it first came out, I was like, yeah, this is bad facts, guys. Like it's not going to go anywhere, right? What happens with all of these suits is it takes a little time for the case to evolve. Right. And so plaintiffs come forward and defense attorneys are really smart. And so they find the holes in the cases and they get litigated and they come and they go. It's a process. Right. So the first time's not going to be successful. The second time's not going to be successful. The third time's not going to be successful. And that's exactly what we saw happen in the wave of retirement plan cases 15, 20 years ago. But you keep chipping away at it until you get it right. That's what the plaintiff's bar does.
I'd love to provide a little context for employers that may not be as familiar with this as you and I. So the breach of fiduciary duty, that's happening due to ERISA, right? Because ERISA states that fiduciary is the highest legal ethical standard, and all plan sponsors have a fiduciary responsibility to the beneficiaries of the plan, right? And we saw this happen with 401k lawsuits, and then actually Donovan, when we first started our business about a decade ago, we put all of our eggs in the fiduciary basket because he came from retirement and he was like, the breaches of duty, fiduciary duty, as well as the fraud, waste, and abuse happening in health plans is 10 times worse than in retirement. We should design a practice around protecting employers from this. And we thought that the lawsuits were going to come 2017, 2018. And we're sitting there waiting like, man, we've really put we're dying on this hill.
Where's the comment?
Yeah. So we're like shocked that it took this long, but nonetheless, something that's important for employers to understand is the focus of these lawsuits is on the pharmacy benefit manager, which is one of 4 components in every single health plan. And the interesting thing is that if you look at these suits, and Jen, you're going to go way deeper into this than I will, but it's showing that bigger isn't better, because these PBMs are the largest in the country. The brokers on these cases, literally the largest in the world. The carriers that are attached to these PBMs, largest in the country. And I think it really dispels the myth that bigger is better, or that you can't get fired for hiring IBM. You can't get fired for hiring Cigna. Well, you can get sued. So let's talk a little bit about that. Like, where are you seeing the breaches of fiduciary duty in this JP Morgan case?
Absolutely. So essentially what's happening here is where, and we've got, there's a big 3, and we they're pretty well known who they are, so I don't need to go there. But essentially what's happening is where the cost of these drugs are literally hundreds of times the cost of going and getting them, going to the store, getting, just buying them directly in the store. You can go and purchase a drug, a 90-day supply, generic, for maybe $50 to $100, but then we're seeing a health plan charge $1,000 to $10,000 for the same exact prescription. So why is that happening? It's a practice, spread pricing, where when we're going through these PBMs, they're keeping the difference in the cost from what they're purchasing the drug from the manufacturer at, and then selling it to the health plan at. And that's the practice that's essentially being attacked or said as, violating the fiduciary duty of these plan sponsors, that they're supposed to know and understand as a fiduciary how their health plan works. And that having a vendor or an intermediary engage in this type of a practice doesn't matter that you've, outsourced to a third party. because you're held to this heightened legal standard, you have to know it. And, ignorance isn't a sufficient excuse.
Right, which I find really, really interesting about this because, with certain reporting requirements and other compliance, there's like the good faith effort. That doesn't exist with this. And, it's not enough as an employer to trust your broker or to trust your consultant or to assume that somebody somewhere in this ecosystem of your health plan is managing and monitoring the performance. So let's talk a little bit then about okay, so PBM, specifically in the JP Morgan case, there's a MS drug, a multiple sclerosis drug that the JP Morgan plan would pay $6,300 for, but the cash price is $11, right? So that's to Jen's point. It's hundreds of times. It makes no sense. Like, this is a huge, probably Fortune 100 company, if I had to guess, if not, bigger. And they're paying that much, and they have insider information on the industry because of Haven, a failed venture, because of Morgan Health. They were members of coalitions, which is where these purchasing groups of employers come together. One that they're a member of specifically is a huge critic of PBM practices. So one thing that I noticed about this case, and tell me if I'm right or wrong, it seems like there's a little bit more of like, hey, you're a hypocrite because we know you're attending these seminars. We know you're parts of these groups that are actively talking about the mismanagement of the PBM, yet you still chose CVS Caremark, who is a huge banking client. Is that different compared to the other lawsuits?
It is different. That's an additional element in this one. What's interesting is from a purely legal perspective, it's not sure that part's going to hold up.
Oh, really?
Yeah.
It's just like, duh.
It's just like, duh.
Yeah.
Yeah. So when the really wonky lawyers get there, we're like, yeah, we're not sure that is actually part of it, right? So, you'd like to think that they should be held to a higher standard for having all of that knowledge. The standard is that they need to act as sort of a reasonable guardian of the information. And the reality is that every plan sponsor is held to a standard of knowing and understanding how their plan works.
And that is not something that can be outsourced.
And that is not something that can be outsourced. And it's no more an issue that JP Morgan didn't do this as it is that, any other large company wouldn't have done these, because these are basic things that aren't being done, right? Like $11 versus $6,000 is maybe not kindergarten, but at least third grade math, right? So we don't need to be the height of the industry and the industry insider to know that. And so as much, I mean, that other part is a really mad, like, come on, get it together, headline news type of a thing. And it's there to get people's attention. But the legal principles here, you don't have to be JP Morgan to know better than to pay 1,000 times the cost of the drug.
And explicitly enter into contracts that state we are not PBM contracts. We are not a fiduciary. I read a compensation disclosure from a publicly traded brokerage yesterday that it had this whole disclaimer on, like, we are not a fiduciary. We don't consider ourselves fiduciary advisors. I understand that the only person or only entity liable as a fiduciary is a plan sponsor. I get that. But why wouldn't you, if you're a plan sponsor, align yourselves with consultants, PBMs, stop-loss carriers, TPAs, networks, all parts of your plan that are at least acting on the basis of the principle of fiduciary? I think that is probably the number one easiest step on, like, how to avoid lawsuits, and then also documentation, which I'm sure we'll get to today. But the next question I have for you, you mentioned standing. So I don't know that everybody knows what that means. And from what I can tell, non-legal, trying to simplify this, is like, there wasn't a clear-cut connection between the Lewandowski and the Wells Fargo case and the fact that employees were paying more because they already hit their out-of-pocket max, or their former employees. So is it correct that the JP Morgan case is showing for current employees and a more direct correlation between mismanagement and heightened costs for employees? Is that what standing means?
Well, that's what they're trying to do to prove that there is standing. So what standing means is they have to be able to show, and this is like when you use a courts to do something, you have to prove harm to the plaintiff. So you have to be able to say, in order to use the courts for redress, that the individual plaintiff involved was harmed by the act. So what's a little bit more complex in a health plan case than in a retirement case is you have to prove that that fiduciary act hurt the individual plaintiff involved. And so that's what we're talking about when we're talking about standing. We have to prove the harm so that we can prove that the courts are, that there's redress available from the courts. So I can't just say, you did something wrong, Chelsea, so I'm going to go sue you for it. I have to say, you did something wrong and it hurt me. And therefore I'm going to sue you, and the court's going to be able to do something to fix it for me.
Am I wrong to be annoyed that judges are not understanding that if you're paying $6,000 for a drug instead of 11, that will increase your premiums for all employees next year and cause harm? Like, to me, it's like, how, like, come on, we know how healthcare works, right? The higher the claims, the higher the premium next year. So if we can pay less for a claim.
So what has to happen is we got to prove all of those. Every single thing you do in a court has to be proven. And when you actually read those cases, they didn't prove every one of those steps along the way. And they actually didn't. So when you go in and you read the claims and stuff, like when you put together a filing for a court, you have to prove every single step. So what they failed to do, and this is the J&J case, and that, you know, they're starting to do a better job along the way, is say, when the plan pays X, it goes into these actuarial calculations, and the actuarial you got to prove every
impact premium.
It's like, remember like geometry class now, you know, when we had to go in and prove that those theorems we had to write.
Show your work.
Yep. Every single step of that entire process. So we know it because we work in this industry, and the direct causality between paying the $6,000 versus the $11 and the premium rates. It's all intuitive to those of us who spend time in this industry. But think about what courts do, and courts are asked to redress things, everything in the world, all day long, every day. So the only thing that exists in a court is what's written down on that piece of paper and then ultimately proven in a court of law.
You know what I just thought about when you said, like, show your work, is how important that is for employers as a takeaway from these lawsuits when it comes to showing your work for how you came to the decisions about your plan. Whether it is you chose a Cigna fully insured over a self-funded unbundled program that could have saved you $1 million, okay, you're actually not necessarily going to get sued for that decision if you are showing a prudent process and a really good reason as to why you chose that decision. I mean, it's bad all around for probably a lot of reasons, but am I correct in saying that if you're showing your work from a decision-making perspective, that's a whole CYA in itself?
That's exactly right. And that's what it is to have a fiduciary committee, to go through a fiduciary process. And in fact, that's what ERISA is. Fundamentally, it's all about process. So, you know, if you're trying to prove that you went through the process, that you thought that you were thoughtful in this process, the reality is you're going to be okay, right? So you don't necessarily, the way the law works, you don't even have to get it right.
Right.
If you prove that you went through the process, but if you can't prove that you went through the prudent process, you could be up a creek.
So 2 things I've heard recently, and then I know we're going to be out of time quick, so we have to end, but this has really annoyed me. And this is me being like super PG-13 right now, because I have like other things I'd love to say. I know,
we've been being good. You know,
you and I are doing really well today.
We're doing great.
So number one, I've heard ERISA exempt entities like church plans, school boards, public entities say, well, we're not subject to ERISA. So like, basically, like, we don't care about, like, I speak about this fiduciary duty all over the country, and I'm just trying to educate HRs that, like, you yourself personally can be named in these lawsuits. You need fiduciary insurance. You need a framework to make decisions. You need to be documenting, like, you need all this stuff, right? And it's not even like we're selling it to them. It's just education. But there are people that are saying, well, we're not subject to ERISA, so whatever. And then there's other people that are saying who are subject to ERISA, but they're smaller companies, maybe 500 employees, 1,000 employees, 5,000, where they're like, these lawsuits aren't coming downstream. And what would you say to them?
Okay. Um,
Because I know what I want to say.
So what ERISA is doing is codifying essentially basic best practice, what it is to do the right thing, to monitor, and to stand in the shoes of a third party. So, and we can talk about whether or not the lawsuits are going to reach into the smaller groups, and I ultimately think they absolutely will. So I do want to see that relative to size, because I think that argument that they're not going to reach down is just patently wrong. But beyond that, let's just concede that point for a second, which in reality I'm not willing to do. These rules are basic everything I need in life I learned in kindergarten rules. This is setting out, right and wrong, and the things that you need to do to be standing in the shoes and protecting third parties. So if you take a step back from the are they really going to come to get me? I would say let's pause and step back from this for a second and ask yourself the question, do you really want to be making decisions on behalf of people all by yourself? Do you really not want to do that as part of a team? Do you really want to be paying $6,000 for an $11 drug? I mean, we can talk about okay, is the boogeyman really going to come and get me? But I never talk about compliance based on the penalties. Is that really, is that really what you want to talk about? Or do you want to talk about doing the right thing? Because I never like to lead with, the bad things that are going to happen to you.
Yeah, fear mongering.
Yeah, that's never how we've talked about compliance, right? Fiduciary law is at its core a set of guidelines and principles about how to take care of your plan, how to take care of the people in it, how to guard their finances, and how to guide their health. What is fundamentally bad about that?
And once you do that, we'll see that you're going to be rewarded financially. You're going to be rewarded in terms of employee morale, engagement, retention, because there isn't a direct correlation in healthcare between cost and quality. Just because you're paying more for something big and it's some label doesn't mean that your employees are getting higher quality or they're having a better experience. It's actually usually the opposite. So the really cool thing about operating with a fiduciary framework, doing your due diligence, monitoring your vendors, benchmarking your plan, having access to data, the cool thing about choosing to be a fiduciary is what Jen said. A, you're doing the right thing, but B, it's paying off in literally every way that will serve you and your employees. So there is never a reason, and that was my response as well, which is why wouldn't you?
I mean,
right?
Yeah, I mean, fear of lawsuits is absolutely the worst reason to act as a good fiduciary. I mean, if it's going to be your reason, fine, take it. But it is the last one on my list.
Where do you see this JP Morgan case ending up?
I don't think it's going to be the successful one either. I don't think we've yet. Nope, I don't think we've yet to see the one that's going to break through. I think we're gonna still, but I think it's coming, right? So I think we have it, and I don't think that this attorney is going to give up, and I don't think we've seen the breakthrough case just yet, but I absolutely see that breakthrough case is on its way, because these practices are real. Transparency and the need for transparency is real. And there are really, really significant problems out there. And, we're going to continue to see action in the courts. We're going to continue to see action in the legislature. We're going to continue to see regulatory action because the problems are acute. And until behavior changes, we'll continue to see people coming at it from all angles.
If you could give an employer listening to this one piece of advice, take one step in the fiduciary direction if they have no idea what they're doing and no one's talking to them about this, what's the easiest first thing they can do?
Form a fiduciary committee.
And guys listening to this, I'm sure Jen has templates she would share. We've got committee charters, conflicts of interest acknowledgement forms, all sorts of things that we'll share. These resources are out there. That you can't claim ignorance on any of this anymore. It's a thing. It's here to stay. Jen, you are so good at all of this. I absolutely love talking to you. I'm actually really annoyed we're out of time because I'm I have so many questions for you.
I know.
But I really next would love to talk to you about the Assured Partners rebates lawsuit. That
oh my gosh, yes, I will come back. Let's talk about that one. Yes,
okay, good.
Absolutely.
Because that's totally different, but it also is very similar in the sense of just not ethical, good business practices. So where can our guests find you?
You are welcome to find me at mcqconsulting.com. You can email me at Jen, Jen, at mcqconsulting.com. I'd love to chat.
Awesome. Thank you, Jen.